by few, respected by all, second to none. And we just did the intro and everything. The champ is here, and we're gonna make it look good. We're gonna try to make justice look good. If not making it look good, we're gonna go ahead and explain it. That the hook, make it look good, is from Janelle Gray, my daughter, who's a professor here in town at TCU. Shout out to her. And also, since I'm doing shout outs, I will go ahead and give a shout out to Vincent Hall and John Wiley Price. They're selling books over at Sankofa right now, so go ahead and buy you a couple of books. Justice is what it is, and that's why we have Legal Standpoint with Michael Todd here today. What's going on, brother?
Trying to make it, Ed. How you doing, brother?
Man, I'm doing all right, man.
Man, I've been inundated all week.
Yeah.
Everybody calling, everybody talking, asking about this Carmelo Anthony case out in Collin County. Man, that young man took a hit.
Yeah, he took a hit.
Yeah, he took a hit. 35 years in the Texas Department of Corrections. That's not anything to sneeze at.
No.
On a murder case, 35 years, that means you have to do one half calendar. So that would be 17 and a half calendar years before he's even eligible for parole.
And he just turned 18.
Just turned 18, so he would be about 35 and a half.
Right, and another way of looking at that is he'll have to do his life all over again. 17 years old.
Correct.
17 more years.
Correct.
Yeah,
it is. It is. So yeah, that's a pretty major hit. And the thing is this: when you come up for parole, there's no guarantee you're going to receive parole at that time. They're looking at all types of factors when you come up, how you've been doing, staying out of trouble. They look at the facts and circumstances with the case, acceptance of responsibility, all types of stuff. But even before we start talking about the parole stuff, like I say, I've been bombarded all week with people asking me just, what did I think? What did I think about the case?
That's why I only called you on Thursday.
Well, yeah, I know, and actually, I'm supposed to be here the third Saturday of the month.
Right.
But I got the call.
That's right.
And, like in Game of Thrones, I answered the call.
You got to answer the call.
You got to answer the call.
You got to answer the call. When the commish calls,
you got to answer the call. So I was like, well, you know what? I'm going to come on in early. Yeah. I'm going to come in early, do my obligation.
Well, thank you. Appreciate it.
Yeah, so, a lot of people know the case. If you don't know, if you're new to the case, basically there was a interaction, incident, a skirmish, fight, whatever you want to call it, that occurred back in April of 2025 at a Frisco ISD track meet. And at that track meet, there were individuals, it was some type of rain delay, things of that nature, and schools had different tents set up, and Carmelo Anthony was in a tent of a rival school. And there seemed to be some type of interaction where they were telling him to get out of the tent. He took issue with that. There was some discussion. There was some type of physical altercation that occurred, and then one of the individuals that was trying to put him out the tent ended up being stabbed, died pretty instantly from either a knife, a cleat cleaner, whatever you want to call it. So it was a tragic incident because, even from April 2025, you had two young men. You had one person that died, and then you had that was about 18 at the time, and then, of course, Carmelo Anthony. Now, the thing is that this case immediately, Ed, just got injected with all types of, racial animus, I would say. A lot of people, the young man that was killed was white, and a lot of people just kind of took the fact that Carmelo Anthony was black, they took it from the fact that it was like some black on white crime, like he was some gangster, thug member, something, things like that. And so what happened is that, people outside the community, Jake Long, I think his name was Jake Lane. Was it Lane or Long?
Jake Lane.
Jake Lane. And so he was one of the January 6 people that was up there rioting. So he had a little platform, so he started using that, trying to make this a white-black thing. And you've had other individuals, other entities that were white supremacist based. You know, they've been from the jump. They tried to make this a white-black issue. They were trying to say that it was some, you know, that the good Caucasian boy was killed by some thug black person or black kid. And so they were just trying to make it where it was not only about race, but it was also about stereotypes and trying to play this young man as if he was just some hardened criminal. And so, you know, it really just kind of, that kind of overlaid over the case. And it got to a point, I think, where it became more of a dominant theme than the case itself, you know?
Right.
And so it was really kind of heartbreaking from that standpoint. And, you know, as a black man, you know, it really kind of upset me that rather than just looking at the case and trying to make a determination on the case, you know, that it was all of this race that was being interjected into it. Of course, when a young black man is being attacked like that, of course the black community is going to come to his defense.
Right.
I mean that's just a natural thing, because we want to do what? We want to make sure that he gets a fair trial as it relates to his case. So that's kind of like the backdrop of the case. And so the case started probably about a week and a half ago. Mm-hmm. And I'm going to tell you right off the jump, Ed, it was a very hard case. All right? It's a very hard case. And, you know, I hear a lot of people, you know, that are supportive of Carmelo that say, oh, like it was just open and shut closed, like, you know, it should have just been an automatic not guilty. And I can tell you, as an experienced criminal defense attorney, that this was a hard case.
All right, now let me go ahead and interject here,
okay,
because I'm not the lawyer in this conversation, you are.
Mm-hmm.
But what we're also talking about is that I want the people that are listening and looking at this to recognize, and actually recognize, not just say, yeah, he's a lawyer. Mm-hmm. In other words, you know what you're talking about. We're not just two brothers just sitting up here and
right. Well, I mean, I've had the law office of Michael Todd specializing in state and federal criminal defense since 1995.
Right.
You know, I've handled murder cases, sexual assault case. I've handled everything from DWI up to capital murder. I've handled cases not only throughout the state of Texas, but also within 14 different states around the country as it relates to criminal cases. So being able to break down and look at and analyze a case, that's what I do. So there's no problem with respect to that.
So social media, all this stuff that you read and see in social media and comments and stuff like that.
Right.
Just
well, the thing is this: the social media comments, they take off, number one, from the fact of the racial overlay that I've talked about so far, right? That has taken over this case. Whether you're pro or whether you're against Mr. Anthony, right? If you pro Mr. Anthony, then hey, your position is that, well, you know, whatever he did was right, okay?
Can't do no wrong.
Can't do no wrong. If you against Mr. Anthony, then he was just some thug, and he just, you know, he was some black dude that took some, you know, innocent Caucasian boy's life, you know. And we do have to be mindful of the fact that a person's life was lost in this particular case. And so that's one of the things that makes it hard, right? Of course, that. But when you look at the application of the law as it relates to this particular case, from the initial reporting of the case, and, you know, I listened to see what type of reports are coming out about what happened, what didn't happen, things of that nature. And so I knew back in April of 2025 that this was a tough case. This wasn't a lay down case. And why do I say that?
Okay.
The thing is this: you have to say, you know, you have to look at it to see if he can raise a self-defense issue, right? And when you're looking at self-defense in this situation, the things that in my mind that would have allowed him to have a self-defense issue that could have possibly be successful was that we needed to look and see how many people were actually attacking him initially, all right? Mm-hmm. We call that in the law the multi-assailant rule, right? Or a multi-assailant scenario, meaning there was more than one person that was actually trying to initiate an attack against an individual. You follow me? So, if it was a multi-assailant rule, and I knew that the young man, the deceased young man, his name is Moncrief. Is it Moncrief?
Metcalf.
What is it?
Metcalf.
Metcalf. So I knew Mr. Metcalf, the young Metcalf, had a twin brother. And so there was some allegations that the twin brother and maybe other members of the track team that he was a part of had initiated some type of attack on Mr. Anthony.
Right.
Now, if that was the case and we had a multi-assailant type situation, then his actions may have been justified, depending upon what specifically was happening, okay? Now, what would have been the best thing, Ed? If it was multiple people that were attacking him and they were beating him down, right? Then that would have been a situation where production of a knife and using that knife would probably have been, or you would have a better chance of that being determined to be a reasonable response to what was going on to you. People hitting you, things of that nature. In a case like that, if I'm the defense attorney, what do I want to see? I want to see my man beat up, okay? And
that way you could use that
to say that he was being attacked
okay.
by multiple assailants, right? And that it just really wasn't a situation where, somebody just, tapped him on the finger, right? But where they were actually putting some bees on him. They were whooping him. So he had to resort to what? Production of the weapon and deadly force, all right?
Okay.
So that's one thing to look at, all right? So if I didn't have a multiple assailant situation, then as I'm thinking about the case, I'm like, okay, let's look at it to see if he would have been justified to produce a weapon in the first place, all right? Now, there's a provision, everybody understands self-defense. If I hit you in the jaw right now, Ed, you have a right to hit me back.
Right.
Right? So I use force on you, I hit you. You can use force to protect yourself and hit me. You follow me? Focus in on I said force, all right? There is a provision under the law called 9.04 of the Texas Penal Code. And it basically says this: if you have the right to use force, meaning Ed, in my example, you hit me. Now I have a right to do what? Hit you back.
Correct.
With force, right? So this provision under 9.04 says is that if I have the right to use force, then I could also, rather than hit you back, I could produce a weapon, right? To tell you basically back up. If you don't back up, then I'm going to be forced to use this, right? So basically, 904 is saying that rather than hitting you back, that I could produce a weapon. And I've looked at these cases with this. I could produce a firearm, a knife, pick up a
I'll show you something.
stick. Yeah, yes.
Which is produced.
Yeah, right. Now, but there's a limitation under 904. Because remember, in my example, you hit me, and rather than hitting you back, I done pull my gun out, right? Which I can do. Now, it's not proportional for you to just hit me in the jaw and then I shoot you. You follow me? It has to be proportional. So what 904 allows me to do is to pull my gun out to say, hey, you need to back up before I shoot you. To cause the apprehension I would use deadly force, but just as a manner to keep you from continuing to attack me. You follow me?
Right.
All right? So, but what that does is that it allows you then to be able to produce the firearm or to produce the weapon, right? Just because...
Talking to them.
Right. Just because to produce the firearm, to produce the weapon, because you have been subject to force yourself. You follow me? Now, so people probably thinking, well, how does that get us, how does that get him off, from the situation? If I have pulled the gun, if I have pulled a knife, if I have pulled a weapon after I have been subjected to force and told somebody to back up, right, to stop, and if that person continued to attack me, right, then it's a situation where they have been apprised that I am armed. If they are attacking me, it's reasonable that they are trying to attack me to do what? Mm-hmm. To disarm me and maybe shoot me. Disarm me and take my knife. Disarm me and take my bat and hit me over the head with it. All right? And so in those situations, the actions or the conduct that occur after the production of, let's say in this case, the knife, could lead to me being able to take additional action, which could be I stab the person. You follow me? So those are the two frameworks that in my mind, in my experience, I thought could be successful as it relates to a defense. Mm-hmm. Now, the question is, do we have facts to support either one of those scenarios? You follow me? And so that's when you have to look at what the facts of the case are, and then try to develop or place that particular situation, right, in one of those frameworks. Or something else, if the facts show some other defense, then of course you would try to do it there. But, as I read some of the articles back in April of 2025, I was a little concerned because, one of the things that concerned me was that in my second scenario, because it appears that there was some force that was used against Mr. Anthony. And the thing is, though, is that, remember, if we're looking at the situation under 904, where I'm responding to force, my initial pullout of my weapon, my bat, my gun, or whatever, is based upon what? I'm causing the apprehension that I will use force, not that I use force. You follow me? And so in the initial reports, it seemed as if the action of Mr. Anthony may have been pretty instantaneous with the force that was being utilized against him. And so that caused some concern from me, from my standpoint, of whether that defense would be actually available and or successful with respect to 904. So, I mean, it was a hard case. And then, so what we did, of course, I wasn't at the trial. And, everybody's piling on the attorneys. And I'm not trying to say the attorneys did a great job or the attorneys did a bad job. Because the fact of the matter is that I don't know what the attorney knows. All right? They've been involved with this case since April. I've heard some complaints where people said, okay, well, they only called one character witness during the punishment phase. All right. That's been a big thing. And you know what? Yeah, most times, 9 times out of 10, 8 times out of 10, if I've got a murder case and somebody's is getting convicted, I'm going to have more than one character witness. Especially if Mr. Anthony, he's had, it's my understanding, he was a good student in school. He was an athlete. So it seems like we should have been able to have a number of people who were maybe school teachers, coaches, from the boys club, from the church, things of that nature, that could have come forward and talked about the good qualities that he had, that we would pitch to the jury to say, hey, look, give him a chance, give him some time. Because on a murder case, when you get convicted of it, you can't get probation. There's no probation. You're going to get time, right? And so, but they could have had those individuals to come forward to say, hey, look, give him some time, but give him an opportunity to rehabilitate while he's doing that time, and to use the foundation of goodness that we've seen in him as a base to come out and do things positive in the community in the future. So, those are things that you usually look at. Now, so that's generally how it would work, Ed. But sometimes, man, there are things that are out there that we the people who are not involved with a case that we don't know about. A lot of times, a case will come up, and as a defense attorney, I'm going to send what we call a notice of extraneous offenses, right? I need to, hey, if you got something that you say that my man has done is bad, that you think that they can bring up in a punishment standpoint, or either in the guilt innocence stage, right? Then I need to know what that is. So there have been instances where they have given certain extraneous offenses. And when I say extraneous offense, let's say if 2 years ago he got into a fight and he knocked somebody's teeth out, right? Mm-hmm. Or if 2 years ago, he pulled a gun on somebody, right? Or 2 years ago he got into a fight and he tried to stab somebody, something like that, right? Those could be things that we call extraneous offenses. Now, even though those instances or those incidents may not have been charged, in a punishment standpoint, the state of Texas can still bring that up. And a jury can consider those if they believe the evidence that's been presented to them beyond a reasonable doubt. And they can then take that into account as they determine punishment. So there could have been things that were extraneous offenses, right? That if he had put more people on, that they may have opened the door for the prosecution to start asking questions and inquiring about those things that the attorneys may have found detrimental to their case. Now, am I saying that is what happened? No, I'm not saying that. I don't know. But the thing is that before everybody just piles on one way or the other, right? We don't know what they know. All right. And so those are things that's something, that we need to think about. That's just one aspect of the case, right now. So it was a hard case, man. It was a hard case. It was a hard case from the jump. And so, 35 years, that was a major hit, But we got to look at the case. For a murder case, murder cases usually, time is kind of, it's expected, right? Now, the jury in the punishment phase of the case, they also had, since he was convicted of murder, they could have looked at a concept that we call sudden passion.
All right, now I've heard sudden passion. That's something that I keep hearing bantered about in the media and through social media as well.
Right.
So they said, why didn't they argue for sudden passion?
Well, the thing, I'm pretty sure they did. That would just be crazy not to, in light of the fact that we had a situation that erupted from a, scuffle, fight, or whatever, that was something that was, that was not something that had been, going on between the parties for long periods of time. So it was a sudden type incident. So I'm pretty sure sudden passion would have been raised. So let me explain how this works.
Okay.
If a person is convicted of murder, all right, and in Texas, criminal cases are broken up into two parts. The first part is the guilt innocence phase of a trial. The state puts on their evidence, you cross-examine the witnesses, the jury goes back and they determine whether you're guilty or not guilty of the case, of the charge. In this case, murder. They came back and they found him guilty of murder, all right? So then what happens is that you go to a second stage of the trial, and that's called the punishment phase. And so in that phase, the state of Texas has the burden of proof again. The jury can consider, of course, the facts and circumstances of the case that they've heard in guilt innocence. You follow me? It doesn't fall off the face of the earth. You don't have to put it all on again. They just heard everything as it relates to what happened in the case, all right? The state then could put on additional evidence. They could put on extraneous offenses like we just talked about before. Mm-hmm. The defense, so if they put on evidence, then they'll do that. And then the defense gets to put on evidence. Now, what the defense wants to do is that they can argue from the guilt and innocence phase or from additional evidence that's submitted during the punishment phase that there was sudden passion, meaning that an incident occurred. I'm just going to say it in layman's terms. An incident occurred that just kind of overtook somebody's, the rational thought, and they acted under the influence of sudden passion. All right. And so when they ask for that in the punishment phase in a murder case, then the jury is charged. The jury has an opportunity to be able to say, we find that the actions that he performed were under sudden passion. You follow me? And if that's the case, and they find sudden passion, then the penalty range drops from 5 to 99 to life to 2 to 20. Okay? Because this wasn't something I was thinking about, son. I mean, it just happened.
Right, because according to what I've been told and read, that he came to the track meet with his snacks and everything in his backpack and all like that. So it's not something like I'm getting ready to go to the school to stab somebody.
Right. Well, from that standpoint.
Yeah.
So, but what you have to understand though is that the sudden passion determination is a decision that the jury makes. And so if they don't find sudden passion, then the penalty range remains the same, 5 to 99 to life.
So let me ask you this about the jury. The jury, they would have to determine that in their deliberation process.
As far as punishment is concerned. As far as punishment is concerned. Sudden passion is raised during the punishment phase of the trial to lessen the penalty range. However, even if they said, okay, we find sudden passion is 2 to 20, they still couldn't give him probation, right? It's still going to be time. I had a case a couple of years ago that had a strange little fact pattern to it, and they found my client guilty of murder, and they found him guilty of murder. We raised sudden passion in the punishment phase. Right. They found sudden passion, right? And they ended up sentencing him to 5, right?
So you raised it up in your argument, and then the jury goes back, the jury foreman says we have to take in consideration that? Or?
Correct. And the jury charge will have questions to say, hey, do you find that this was it'll list out the elements for sudden passion, and they say, do you find this meets the definition of sudden passion?
So all 12?
So all 12 said yes. And so that way, so I had asked them, find sudden passion and give my man 2 years, right? They found sudden passion, but they gave him 5. 5 would have been the minimum on the murder case if they hadn't, 5 to 99 to life. So he got 5 years.
So I'm saying this, I'm asking the question because I served as a jury foreman. So that's how that goes behind closed doors.
Right. And the thing is, I mean, that's a discussion that's back there. Now, the thing is this. I mean, there are a lot of different factors that the jury can take into consideration, or what they focused on as they make a determination of whether they thought sudden passion was available or not. All right. So that's a decision that they would make there. But I know for sure, right? I'm not gonna say I know for sure because I haven't looked at the jury charge, but I would be shocked if they had not made an argument for sudden passion in light of the facts in this case, right? Now, let's say this, and this could apply, we talked about earlier the analysis as it relates to, self-defense, the production under 904 for the firearm and all that stuff. In this particular case, this wasn't anything that was ongoing for a long period of time. I've had clients, man, where, them and one other person, they've been shooting at each other for going on a year, And so that may have a whole different scenario versus an incident that just jumped off instantaneously. You follow what I'm saying? Because if I got a whole year that every time I see Oogie, he upping on me, right? Then I ain't got to wait for him to up because I know he's gonna up because that's what he's been doing for that's how the brothers say it, sometimes. Oh, that's how a lot of people say, he upped on me. He upped on me. So it's up meaning they pulled a gun out.
Well, thank you. I appreciate that,
right,
Counsel.
okay.
I'm not up on my urban.
Oh, come on, man. I don't even want to hear that, man. So yeah, I mean, so this was a hard case, but one of the things that really worried me is, from a legal standpoint, like I said, I knew it was going to be a hard case, but the whole thing that we started with, how they made this such a racial situation, and the thing is that, the supremacist folks jumped on it immediately, just started, this boy had a good grade point average, was going to school, was an athlete, so nothing just showed up as if, he was just some troublemaker or something like that. And of course, like I said, there's going to be a situation where, when attacked like that, our community is going to come to the defense.
And the defense, the verdict was guilty.
Right, yeah. After they went through all the evidence, right, that jury determined that it was guilty. Now, one thing that's been getting a lot of discussion is the whole fact that there were not any black jurors that were on the jury. All right, and so let me kind of talk about that because that could be an issue. That could be an issue that could be advantageous for Anthony down the line. All right, so. This is what happens. You have jury selection. And on a case like this, man, they're going to bring in just a whole lot of people. I think they brought in 500 people to find 12, right? And so what happens is that you go through and you start asking these questions, and you ask these questions maybe in blocks of 50 people or whatever. And you're taking that as the attorneys, as the questions are being asked, we attorneys would take it down responses, things of that nature. Well, we have something that is called preemptory challenges. A preemptory challenge just means I can use this challenge to get rid of somebody for any reason I want, except I can't use it just to get rid of somebody because of their race, ethnicity, original origin, sex, gender, things of that nature. All right? You can't do it for that reason. So what happens is that the state gets to use their peremptory challenges, and the defense gets to use them too. I got 10 people that I can just strike for anything I want, as long as it's not for one of those reasons I just said. Well, let's say we have a situation. You had, out of all the jurors, you had 50 jurors there, and out of all the jurors, there were 3 black folks, right? And so they decided that they were going to strike all 3 black folks. And the question would then be, you see a pattern there, right? You see 3 black folks that have been struck, right? And so the question then in your mind as a defense attorney is, why are they striking the black folks? Now, there are a lot of times that when I'm sitting in a trial or going through a jury pick, they strike some black folks, and I know why they striking them. Black dude might get up and say, I can't consider the whole range of punishment, right? I can't give him, I can give him 5, but I can't consider 99 years of life, right?
He's gone.
He gone, right? You get people to come in, and folks, man, I mean, when you appear for jury duty, listen to me, folks. When you appear for jury duty, answer the question that you asked. I'm gonna say that again. Answer the question that you are asked, because folks feel that that's their opportunity to tell everybody on that panel and to show everybody I'm not scared to tell y'all how I feel about everything. And when you start going on rambling and rolling about how you feel about stuff, then 9 times out of 10, you are giving them a reason to get rid of you with no problem. answer the question that's asked. That's the biggest problem I have with folks. Folks come down and they want to use this as an opportunity to let everybody know how they feel about stuff. Mm-hmm. That's not the time. Answer the questions that are asked. So what will happen is you see the 3 black folks that get struck. And so you say, hey, look, I'm a member of a minority group, right? The state has exercised their rights to peremptory challenges. They used 3 of their 10 to get rid of all the black folks. Judge, I have established what we call a prima facie, which means I have just established, shifted the burden of proof that the state has to now tell me why they got rid of those people. All right? If they can give a race-neutral reason, then from that standpoint, that generally will say, okay, it wasn't for race, it was for some race-neutral reason. Now, in this case, I've read where they said that they thought that these 3 black folks happened to all be educators. A lot of times people from the state, they don't want educators because educators work with kids a lot, teenagers, things of that nature. And a lot of times they tend to think that, hey, look, we're going to give this person a second chance. So people, a lot of times the state doesn't want educators. I mean, but it depends on the case. All right. So the issue would be from the defense, when they give that neutral explanation that they were educators, the question would then be, were there any other educators on the panel who were not black that they did not strike? You follow me?
I follow you.
Because if you're saying you don't want the educators, these black folks because they educators, if you got 3 other white folks on there or 3 other Hispanic folks that are on there that are educators also, and you didn't strike them, then the question becomes why the black folks versus not the white folks or the Hispanic folks.
That means I got you now.
Right.
You know you're messed up now.
And you know what? And sometimes it could be they could give a race neutral reason, but it could be the number. I had a case years ago where they had 10 strikes, 7 of them were against black folks. And so when I made the argument, I was like, Judge, they used 7 of their 10 against black folks. And just left one brother on there. And when that, when that resonated with him, he was like, oh, 7 out of 10? Yeah, Judge. Oh, okay. And from that standpoint, we got some people put back on the jury. Okay. But so it's a fact-based inquiry. Now, we've been complaining about the Supreme Court for the last couple of years, last few years. There was just a Supreme Court case that came out in May, if I'm not mistaken, in May of this year, May 28th, actually, just May 28th. And it reinforced the issue with respect to Batson and overseeing the extraneous offense, the peremptory challenges. In that case, when the state gave the race neutral reason, they didn't even allow the defense in that case to try to do the analysis to show, they didn't strike the educators that were white or Hispanic. You follow me? And so the Supreme Court reversed that and sent it back. So that case. So I don't know what happened as it relates to the Batson challenge, how it was conducted. But that could be something that could be advantageous for him.
For an appeal.
For the appeal.
Okay. As we go to a close, what next?
Well, it's of course he's going to do the appeal, right? But that's going to go through the regular course. They'll file the appeal. And what people need to understand about an appeal, because people say I'm gonna do an appeal, right? Or I get clients say I'm gonna keep my appeal rights. An appeal is not a do-over. It's not like you get to go to court again and we're gonna put the evidence on.
It's not like the Knicks playing San Antonio.
Right. No, it's not like that. It's not like that. It's not a game again. What an appeal does, it looks at 2 things. It looks to see if the trial court, the judge, made any errors that would have affected the outcome of the case, right? In the example we just talked about, maybe there's something there as far as striking the black jurors, all right? The second thing that the appeal court looks at is to see if there is sufficient evidence to support the decision that the jury made, all right? So it's a limited inquiry, right? You know, I would say, I don't have the exact figures, but if I just had to go off, I would say that the chances of an appeal success is probably 12% at best, you know, over time, you know, looking at cases. Because the Court of Appeals, they look for any reason that they can to ensure or to affirm the determination that was made before. They can say, I had a case one time where they said the judge, he gave an improper jury instruction. He didn't let me have what I call a lesser included offense. When it got appealed, the state of Texas admitted that it was improper, right? That he should have had this lesser included offense. And my man had gotten the minimum, right? So who's to say that he would not have gotten, let's say, the maximum on a misdemeanor rather than a minimum on a case? And this was out of Denton. But anyway, even though there was error, the Court of Appeals said that it was harmless error because it didn't really affect the substantial rights of my client. And so the thing is that, you know, everybody gets geeked up as it relates to the to the appeal, but an appeal is a very limited right. It's not a do-over. Everybody thinks that you're gonna get to go in and, you know, pile everybody on and we're gonna have testimony and all that. That's not how it works.
And we can bring up and you guys, you have to come back next week, whenever the next time you come back on.
Right. Yeah.
And we'll talk again about this, because then that means we could go ahead and talk about Jeff Metcalf's.
Because you know what, the whole thing, and I just want to say this because this goes back to this racial thing again. You know, there was a gag order on this trial, meaning that people could not comment. Parties, people who were parties to the offense, to the action, they couldn't comment about it. And so once the case was over with, Metcalf, the father, oh man, some of the stuff that he said in this little deal was just racist.
That's why I said we have to come bring you back, man.
Right.
This is straight up racist.
Yeah, it was just racist. I mean, he's talking about, he called him what? Watermelon felon. Watermelon felon.
Yeah.
He said black folks,
he was straight up racist.
You know what DEI stands for? It means I don't have to be qualified. I just have to be a certain color or race or gender. I mean, it was just really bad, really, to be honest. For somebody to say, and he was initially, when all this first started out, when the white supremacists were coming out, he was saying this isn't about race. But by the time the case was over with, I mean, he wanted the good old boys.
One of the good old boys.
One of the good old boys.
Well, thank you again for coming on.
All right, brother.
You know, we straight up, this is what we're doing on Legal Standpoint with Michael Todd. Hey, we will see you, man. I want to ask you in the lobby when you're going to come back, because, you know, we got a lot more to talk about. But
right.
Thank you for tuning in, and we will see you back soon. Take care. Who was that masked man? You mean you don't know? That was no masked man. That was the commish. Saturdays from 5 to 6 p.m. on the Fishbowl Radio Network. Hey, how you doing? This is Ed Gray of the Commish Radio Show. Stay tuned and tune in and be up to speed on everything in social justice, human rights, and politics on the Commish Radio Show, airing every Saturday, 5 p.m. on the Fishbowl Radio Network. Jump in.
Hey y'all, it's Cynthia Patrice, and when I'm not coding an app and working on Beauty Field, I'm listening to the Commish Radio Show, Saturdays 3 to 5.